All rise. The honor.
Good morning. Welcome to your North Carolina Court of Appeals. My name is Chris Dill, and I'll be presiding today. To my right is Judge Valerie Zachary. To my left is Allegra Collins. Welcome. We have one case on the calendar. It's Munn versus Rose, and if the appellant is ready, you may proceed and let us know if you want to reserve any time for rebuttal. You may proceed. And welcome.
May it please the court, my name is Mark Hayes. I represent the plaintiff payee Albert Munn, who's here today. I'll be doing the opening 20 minutes of argument. My co-counsel, Mike Harrell, will be doing 10 minutes of rebuttal at the end. Your Honors, ultimately this case is about reconciling, or failing to reconcile, two provisions in a note. One of those provisions is that a note becomes due as applied to the fact of this case, a house sale. The other is that the note is only due if the defendants survive Patricia Munn. Let's begin by anchoring ourselves in a simple legal definition. What is a date of maturity? A date of maturity is a date that the note becomes what? Due, right? What can we say about a day that we know the note is not due? We know that date is not a date of maturity. Date of maturity, date that it's due.
So is it your contention that a loan cannot mature if a condition precedent hasn't been met?
No, the condition precedent has to be met when it's due, whether by timing or whether by some other trigger. That date is the date of maturity. There is no independent concept of a date maturity beyond the date that something's due.
So how does the condition precedent work into your analysis?
Right. So the condition precedent is an independent way or an independent provision that has to be satisfied, just as the timing provision has to be satisfied. Those two things together, when they're both satisfied, create a due date. That's one way.
So they have to be together. So if the note says it's due on this date, it's actually not due on that date unless the condition precedent has been met. If it hasn't been met, then you have to wait until the condition precedent has been met, and then the note will mature.
That's right, Your Honor, and I think the parties are actually in agreement that the two provisions have to be read together, because we see in, well, let's take a look at the defendant's argument. They argue in their brief, the note provides for one maturity date, that is the earlier of September 6, 2029, which is 10 years, or the sale of the Shaftesbury property. So using the date of maturity as a definition, they're basically saying there's one date the note is due, the earlier of 10 years or the house sale. 10 years is indisputably inapplicable here, so really it boils down to them saying the date of maturity is the house sale. But of course they don't really mean that, right? Because when the house sale happened in March of 2023, we sent a demand letter saying, pay us the note, and they said no, because of the other provision. Survivor provision. I'm sorry, Judge Zachary, you looked like you were just about to ask me a question.
Well, I'm just wondering, you know, so is it your contention that there are alternative dates of maturity other than those listed in the note?
There are at least, there are a number, yes. There's not one. And we see the defendant in their brief emphasize this idea of there is one date of maturity, but of course the word one doesn't appear anywhere in the note. So a few different possible dates of maturity. One we have built into the timing provision, the earlier of 10 years or the house sale. So that's already some flexibility there. We also have what actually happened here, which is the satisfaction of the condition precedent, Patricia dying before the house sale, or rather the Roses surviving Patricia because they're still living. And so because that hadn't been satisfied, when the house sale happened, you had to wait until Patricia died.
Yeah, I was going to say, you said Patricia died before the house sale. You meant
Yeah, I mean.
You meant after.
Yeah, right, so they have to survive her. There's also another way that the note can mature. Again, mature simply means the note is due, and that's the default provision. So there's,
But didn't the parties agree to the default provision?
they did, yes, Your Honor.
You know, isn't that different than saying that they agreed to just, to basically any date on which the condition precedent is satisfied?
I'm sorry, Your Honor, could you rephrase that? I just didn't quite follow.
Okay. They agreed to the default provision,
Right.
right? Did the parties agree that the date of maturity could be any date on which the condition precedent was finally satisfied?
I think they did, because the memorialization of their agreement is, of course, where we start in all contract analysis, the text of the note, right? So the note says, regarding the default provision, this is page 11 of the record, at the option of the holder, any of the following shall constitute a default, etc. It will become immediately due and payable. And then the end of that paragraph, the holder, this is one of the reasons he can call the default, in good faith believes himself insecure for any reason. So the note itself is contemplating whether Patricia has died or not, whether the house is sold or not, whether 10 years has passed or not. There can be a date when it's due and payable. That is a date of maturity, right? That's one way.
But under certain circumstances.
Right, under certain circumstances, but terribly broad circumstances. And I would say circumstances that were applicable here. When the house sold and Mr. Munn realized that his collateral for his loan was, moving to a third party, he demanded the payment on the note.
Did he reference the default provision?
I don't believe he referenced the default provision, but ultimately it comes down.
Was this argued before the trial court?
It was, in the sense that there was evidence submitted, the demand letter, and
But-
talked about.
But was there any argument before the trial court that he was entitled to relief based on the default provision?
Not expressly, Your Honor.
Okay. Thank you.
In any event, the existence of that lets us know that we're not just talking about this one particular date. What is the defendant saying when they say date of maturity? What are they really saying? Well, they're not saying it's the date it's due, because otherwise they would have paid when we sent the demand letter. So what is their definition? Their definition is not based on the text of the note at all, but basically it's the day on which you assess whether the note is due. And then there's a second part to it. If you assess that it's not due yet, it's the date on which the note terminates. They're saying the house sale happens, there's this date, it's called date of maturity, but it's not an actual date of maturity, and they say that because they didn't pay on it. We assess, is it due yet? The answer, everybody agrees, is no, and they say the note fails. There's no textual basis for that at all.
So by the plain language of the note, what do you think is a consequence of the phrase that the amount is only due and payable if defendants survive Patricia Munn?
Right. That obviously has to happen before it becomes due. It's a condition that will be resolved at some point, one way or the other, because everybody dies, right? So it's not going to be out there forever. At some point, she will have either survived her children or they will have survived her. So it's pending for some period of time, which is another reason why are you going to just terminate it at this date as if it can never be satisfied? It will be satisfied one way or the other, yes or no. And so the date of maturity becomes after the house sale. Well, we still have this other condition pending. It's so important, it's like right at the top of the very note.
Yeah, let's talk about the order of that. So when we look at a condition precedent, the principal amount plus interest is due, and we have that they must survive,
Right.
correct? Then later, we've got essentially the maturity dates that we're talking about,
Right.
correct? What is the significance of having the condition precede the maturity date?
I don't know that there is any.
Then why in your brief did you switch them?
I think because everyone is, I don't know that I did that with any deliberate purpose.
Because I think when you read it, there's a natural chronological order of that, and the consequence of that lines up, no?
Well, if that were true, then I guess you would put the default provision, which could trigger a due date before any of that happened, at the very top. But of course, the default provision is at the very bottom. So
And that seems to be sort of a catch-all. I guess you call it either a default or a catch-all.
Right.
Okay, so that would seem to come at the bottom when you catch all.
that's right, but it would be out of order. I don't know that. I don't know why I would read the order as being particularly significant without any textual support for this has to happen first. We don't have anything that says this condition precedent has to be satisfied first and then this other thing happens.
I guess I'm confused about why we call it a condition precedent or precedent when we're saying, well, it doesn't have to happen before the maturity date.
I'm sorry, there was.
So why are we referring to it as a condition precedent or precedent?
Right.
When we're then arguing on the same side that it doesn't have to have happened before the maturity date, then that doesn't make it a condition precedent.
It doesn't have to have happened. Well, it does have to have happened before the actual date of maturity. That's where the date of maturity as read in isolation is confusing, because date of maturity, everybody agrees, is not the date that it's due. But we all know date of maturity is the date that something is due. So when it uses the phrase date of maturity in paragraph 2, I suppose, that's the only place that appears in the note. So that date of maturity is a date of maturity within the context of that particular provision, but it's not this galactic, it has to be that date, as we know from the default provision, among other things. It's just the date that would be satisfied between those two timing provisions. But it's not going to be due on that date if you don't have that first condition precedent satisfied, and defendants agree with that, because when the house sold, we said pay, and they didn't. And what was their excuse? Because the condition precedent hadn't been satisfied.
So then the argument is the condition precedent, the date that happens actually becomes the date of maturity?
On the facts of this case, yes. It could have happened a different way, but they both have to be satisfied. You can't just ignore the condition precedent. It has to be satisfied. If it happens first, then the dates of the alternative timing provision between the 10 years and the house sale, that second one, that's the date that I guess they all are satisfied, and therefore it's the date of maturity. But it could happen the other way as well.
But you're not ignoring it if at the time of the dates of maturity that at least this note say that condition hasn't been satisfied.
Right. We're certainly not ignoring it, and defendants obviously didn't ignore it either, because they refused to pay. When their date of maturity, the house sale, happened, we asked for payment. They said no. And why did they say no? Because the survivor provision, that condition precedent, hadn't been satisfied yet. So we're all in agreement that they both have to happen. The difference is that they're saying at that point of assessment, I guess, for lack of a better word, even though that's not based in the note, that we decide, that's a point where we evaluate, has every condition been satisfied? And if it hasn't been satisfied, the note fails. And that is just why. Why does the note fail? Because they were satisfied in a particular order. There's no basis for that. There's no like, this all has to be done by this certain date in order for it to be satisfied. If it's not done in this particular way, it fails. It's just an inference.
When did you think this money became due? When Patricia Munn died? Is that when it became due?
On the facts of this case, they became due under those first two paragraphs, setting the default part aside, when Patricia died, yes. Because at that point, you had satisfied both of those provisions that we're talking about, the surviving and the earlier of the two dates here, the house sale. Right.
Does a default provision actually allow for alternative dates of maturity, or does it just allow for the acceleration, of when the amount is due and payable?
I think your question, the date of maturity, again, this is where it gets very confusing, but date of maturity as a legal concept is the date it's due. So if you accelerate, that date that you demand is a date of maturity, because it's the date that it's due. There is no such thing as a date of maturity.
Well, it's but it's an accelerated.
Right, it is an accelerated. But the definition of acceleration, which I have somewhere in here, in any case, I had that in an earlier draft. That's the definition of acceleration, if you look it up in Black's Law Dictionary, is to make something immediately due. And so, by definition, a date of maturity
In full, in full.
in full, yeah, in full, yeah, absolutely. Yeah, if we look at the, and again, this is page 11 of the record, the 4th page of the note, it says it's due in full. Constitute at the top of that paragraph, at the option of the holder, any of the following shall constitute a default. Upon the occurrence of any of the following, all obligations hereunder shall, at the option of the holder, become immediately due and payable. Therefore, that you can make a date of maturity from just the default. So that again undermines their idea that there's this date that it has to happen. The note is already considering that it doesn't have to happen on that date.
But you can't have an acceleration, or you can't choose a date if the contract is no longer enforced, right? For example, a condition precedent wasn't met and the contract is, and the note has failed.
I don't know how that would, no, I think, Your Honor, actually, none of the other conditions, the only if and the house sale, those conditions cannot be satisfied at all. There could very much be a factual scenario where you know you're only going to get paid out of the equity of this house. The house burns down. Payer says, I'm really worried I'm not going to get paid. Patricia hasn't died yet. House hasn't sold. 10 years haven't passed.
True, but at that point,
He still has a right.
it's right. The note is still enforceable, correct?
Right, right.
But
So I think you would have to have a,
if it weren't enforceable anymore,
Right.
then these don't ever kick in.
right. And so the way that that would happen would be if the condition precedent was resolved against Mr. Munn. So it requires that the defendants survive Patricia. If both defendants get hit by a bus and this becomes a question of like a claim against an estate, the note would have failed at that point because they did not survive Patricia. But that didn't happen. That was pending for all of this time. So the question then becomes, why do you definitively resolve something that's pending? There's no reason to. I just want to touch briefly on some of the other, I guess, reasons that this note was ultimately interpreted in the wrong way. And I don't want to belabor this, but there's a lot of findings in the order about how this should be construed as part of an estate plan. That's inappropriate for a lot of different reasons. The note doesn't mention an estate plan. Plaintiff did not agree to a estate plan, and we challenged finding 33 that he had adopted some understanding of this being part of a estate plan by signing a will addendum. You look at the document. He didn't. Interpreting this as a estate plan would completely shift how you assess the note. You'd be looking at the intent of the testator and not the intent of the parties. This is a contract. You're looking at those. So that puts you on the wrong track. It's just one kind of fun example. If this were a case about funeral expenses, somebody dies, their son contracts with the funeral home to bring the flowers, buy the coffin, that sort of thing. Would we assess that contract in light of what the testator wanted for their funeral? No, we would assess it between the son and the funeral home and those terms that they negotiated. So the idea of
Well, is this relevant if we find that the note is the language of the note is plain and unambiguous?
Absolutely not. I think you can resolve this on the text of the note. I just am adding this as this is basically like, okay, if it falls through there and you get to parole evidence, then there are a lot of findings about like how this should be construed as an estate document. We're just saying, even if you get to that level, it wouldn't be supported.
What would our review of those findings of fact be? Are they just for any competent evidence to support findings if we got there? Or is it all de novo and we disregard the findings in a bench trial?
I mean, I think any finding of fact based on competent evidence is going to be supported and binding as to this court. I will offer a warning that some of the findings are misleading if you overread them. So there's, for example, one that plaintiff said something about when the house was going to be due, and that is true. He did say that, but he's not a lawyer, so it's not that he was taking a legal position. So there's a couple things like that. But in general, yes, any findings are going to be, if they're supported by competent evidence, are going to be binding. And we've listed out the findings we're challenging. I'm not going to recap those at the end of our brief. One final thing I'll just end on is if you step back and you ask yourself, what's happening here? What were the parties negotiating for? What was their disposition that we can kind of inform how we interpret this? Obviously, these are family members, right? You would hope that this sort of thing would be resolved in a handshake. It's not. There are obviously a lot of trust issues here, so they're reducing this to a contract. What effectively happened here was that the defendants unilaterally, without any input from plaintiff, without any advice from him or his ability to do anything, they basically unilaterally got out of this note. Does it make sense that when they were negotiating this note, plaintiff would have agreed to something where the other side could unilaterally get out of the note?
Did the parties, in fact, negotiate this note? Because it's my understanding from the record that mother went to her attorney,
Right.
who your client paid for, and the attorney drafted this. There's no indication in the record that the parties negotiated anything.
Well, right. It was written by that attorney. It was then adopted by defendants who presented it for signature. But in any case, as we're looking at the intent, I think it does make sense to ask, does this even make sense? But I would stick mainly to just the plain text of the note, and I think that resolves the case in our favor. Thank you.
Thank you. Morning.
Good morning. May it please the court. My name is Bo Caudle, and I represent the defendant Elise. This court should affirm the judgment below for any or all of three independently sufficient grounds. The first is that the trial court correctly determined that the plaintiff had failed to prove that anything ever came due under this note, and therefore had failed to prove breach by non-payment. The second is that the trial court correctly determined that there was never any meeting of the minds between these parties as to what and when the defendant should have to pay the plaintiff under the factual circumstances that developed. Since there was no agreement, there could be no breach. And then third and finally, if the note's ambiguous, and we do not think it is, we agree that you can resolve it on the plain language, but if it is ambiguous, there is a mountain of extrinsic evidence on which the trial court properly relied in making proper findings and conclusions to the effect that the parties did not intend for the defendants to pay the plaintiff anything under these circumstances.
So just to make this clear, is it your contention that if we find that the language is plain and unambiguous, then we don't need to reach issues 2 and 3?
You do not. You would stop there. The trial court could have stopped there because the trial court found that within the four corners of the note, there was no indication that the defendants had a payment obligation under these circumstances. And so the trial court could have stopped there. You can stop there. And I would like to begin there because that's where the trial court began also.
And just for clarity, both sides are saying this is plain and unambiguous, correct?
That's
and
right.
coming to completely polar opposite results, yes?
Yes.
Is that sort of the quintessential definition of ambiguous?
It is if you accept that both sides have taken a reasonable view of the language. And so the challenge that we have is that their interpretation of the language is simply divorced from the text.
And both sides say, well, that side's wrong, it's unambiguous, right? And both sides have the same argument.
As is the case in virtually every contract case I've ever been in. Both sides have a different view of the contract, but that does not mean the contract is ambiguous.
Explain to me, just so I just understand, I'm looking at the contract. They loaned you money for consideration. Why don't you owe it ever?
Well, there's a finding. The trial court found there was no evidence the promissory note was tied to a loan. So that is incorrect as a factual matter on the premise. There was no loan. This note was created. What the trial court found as consideration for this note was that it was created as part of Patricia Munn's estate plan. So she, Patricia Munn, decided to craft her estate plan based in part on the defendant's willingness to enter into the note. That was the consideration, not a loan. But the reason why we don't have to pay under this note is because of the note's plain language. So if we look at that language, can
I just ask one question? Both parties agree that this can be determined by the plain language of the contract, but you disagree as to the consequences of the language.
We agree.
Am I correct?
That's right. We agree that there is a condition precedent. That condition precedent appears in the first paragraph. Judge Collins, I think it was a great question why it appears in the first paragraph. I wish that I had thought of it before now. But I think that the reason it appears in that first paragraph is because it sets the tone for the rest of the document and understanding of what has to happen before any other obligation accrues. We disagree specifically about the timing of when that condition precedent must be satisfied. We say, and we think that this is consistent with the language of the note and with North Carolina law, that it must be satisfied as of the date of maturity as defined in this document. And if I may quickly, just very quickly say that I think a lot of the argument you heard this morning about maturity and what it means is good argument when it comes to the definition of that term as a general matter. But this document defines the phrase date of maturity. So when they say there's nothing in there that says it's one date, well, yes, there is. It is at the end of paragraph 3 where it defines the date, not the dates, but the date of maturity as the earlier of 2 potential events, the sale of the property or the passage of 10 years. So there's one date of maturity, and we should not...
Isn't there a difference between a label that you give something in a document versus the term of art date of maturity when we're talking about a contract?
There's a difference between the term of art maturity and the label. I would agree with that. I would quibble with whether you would port in a sort of common law understanding of what date of maturity means when in a contract the parties have specifically defined that term to mean something else. And here what they have specifically defined that term to mean is the earlier of 2 potential contingencies. So
There's on the last, near the last page is another date of maturity. If there's a default, it can become due and payable. So there's actually, wouldn't that become the date of maturity as well?
So I'm glad you asked me about that because they raised that, and this is the first time, by the way, that they've ever raised it. It was not raised below. The only time the word default was even...
Well, I'm just asking you. I don't care whether they raised. Is that true? Is that part of the date of maturity?
No, it's not. It's not
So
a
it
date.
would not become due if they thought there was a default.
So it's not a date of maturity as that term is defined in this note. The note could be due under the default provisions on page 11 of the record. And what those default provisions say is the note comes due if it's not paid on time. Okay, well, that's just circular. That's what we're talking about here. The note comes due if there's a bankruptcy. No evidence of that, period. The note comes due if there's an assignment for benefit of creditors. No evidence of that. And then the note comes due if the plaintiff makes a good faith determination that he's insecure. And I just have to stress, and Judge Zachary pointed this out, this argument was not made below. It was not. I brought up the term default when I was arguing about the post-default judgment interest rate in closing argument. That was the only time that the word default was ever mentioned at trial. The plaintiff did not testify that he felt he was insecure. That did not happen. It wasn't raised expressly, and it wasn't raised by implication. It is an argument purely manufactured for the purposes of this appeal. In any event, however, there is nothing in that provision, Chief Judge Dillon, that makes it that you could accelerate that debt before the satisfaction of the condition precedent in paragraph 1. So if you accelerate it, if the plaintiff had exercised his option to accelerate the debt while his mother was still alive, he would have been accelerating a debt that was worth exactly $0. Because there's a condition precedent to any payment obligation, period, and that is that you survive.
We don't even know what the principal amount of the loan is until the house is sold or 10 years passes and you have an appraisal done.
That is a fantastic point, and I wish that I had thought of it in response to Your Honor's question, but that is right. You would not even know what the principal amount is at that time. So now, turning back to how the note is structured, I do think that...
What would have happened, and what would have happened if 10 years had passed and nobody had died?
So what would happen if 10 years passed and Patricia Munn was still alive, Alan and Melinda are still alive, nothing would be due under the note. And nothing would ever be due.
So so you're saying if Patricia Munn had died 11 years later, and your client's living on the property and everything, nothing would be due?
That's right. That's right. And so let me, I can't, so I analogize their position to sort of this situation.
I don't understand how that makes sense.
Well, let me try. Let me take a try at it. Because I understand the conceptual difficulty with that. It seems unfair. I understand that. And first I would point out, people are free to draft unfair contracts. Okay, so we're not here to talk about fairness as a matter of plain language. Okay, we're here to talk about what the contract says. But second, think of it this way. Let's imagine I agreed that I was going to sell my car to my friend on April 30th, but only if the Tar Heels were the men's basketball national champions. That's my agreement with my friend. April 30th comes, but whoops, the Tar Heels have lost in the Sweet 16. I don't sell my car to my friend. Under their interpretation of that agreement and this note, if a year later they become the men's basketball national champions, I have to sell them my car. That agreement, that obligation springs to life in their view. And that is not how we traditionally think of conditions precedent. The way we think of conditions precedent is that they have to occur as of the date the obligation accrues. And that's the Kale case. It's cited in both parties' materials. It's a Supreme Court decision about the definition of the term surviving, which I'd never thought was particularly controversial. It means to outlive. That's what the Kale court decides. But what they say specifically is that when you're interpreting that term in an instrument, in that case it was a will, that sets a specific time, in that case it was the death of a devisee, to determine who the surviving heirs are. So the testator dies, he leaves property to a devisee. His will, the testator's will, says after the devisee's death, this property goes to my surviving heirs. The question is, surviving heirs at the time of the testator's death, or surviving heirs at the time of the devisee's death, the time frame mentioned in the instrument. And the court said you look to the time frame mentioned in the instrument. And that is consistent with what we're saying here. We're saying you look to a specific point in time to see if that condition precedent was satisfied. You have to
understand. Why is he being why was this set up? What was he being compensated for? The fact that your clients were living on the property? Is that, and had he paid stuff for the property? I mean, I'm just trying to understand.
So I'll have to pull extrinsic evidence in for this purpose. If the court will permit me to do that, I'll be glad to talk about it. The reason, what the trial court found, and what, frankly, all of the evidence before the trial court suggested, was that Patricia Munn and her husband, as part of their estate plan, wanted Melinda and Alan to receive the lion's share of the value of 6500 Shaftesbury going back decades. That's what they wanted. They wanted them to receive the lion's share of the value because of their recognition of Melinda and Alan's special services to the family's business, and the maintenance of the property. And so Patricia Munn, in the last iteration of her estate plan, because it had become necessary for her to deed part of the property during her lifetime to Melinda and Alan, and because she was concerned that if she just left everything alone, there would not be provision made for her other children in those circumstances, she said, okay, I want you to sign these notes that guarantee payment after I'm dead and you have inherited 100% of the property. That was the purpose of the note. So what they're saying is, okay, well, now she has passed away, you've survived her, and even though you only got 50% of the net proceeds of the sale, because when it was sold, she was alive, and even though you took the 50% that belonged to her, and that money was spent down to pay for her end-of-life expenses, and even though you've given that money to the heirs, $40,000 each to the other heirs, including the plaintiff, you now owe me an additional percentage based on 100% of the net proceeds of sale, which they never got.
So the difference between her dying before and after is 100% went to the Munns, went to them after she died. No, would have gone, 100% would have gone had she died before the sale. 50% went to them when she died after the sale.
That's to the Roses. That's right.
The Roses. I'm sorry.
Yes, no,
Okay.
that's okay. The names get confusing, but yes, that is exactly right. If she had passed away, they would have become the 100% owners of that property,
And they would have owed the money.
and then they would owe the money. That's
But
right.
since it got sold beforehand, the money got split. Some went to her for her end-of-life stuff, and then everything else got...
That's right. And that's why if you do get to the extrinsic evidence, if Your Honor is persuaded by their argument that they have a reasonable interpretation of the note. We think ours is at least equally as reasonable, and you do get to the extrinsic evidence. All of the extrinsic evidence supports the position that the party's intention was to secure payment in the event that Melinda and Allen inherited the whole of 6500 Shaftesbury. And that's what the trial court made several findings to that effect in his order. Looking back at the structure of the note, and I don't mean to take us back to the very beginning, but I do want to make sure that this is laid out in context. Paragraph 1 is where this condition precedent exists. And what it says is that the principal and interest of the note, this is on page 8 of the record, principal and interest payable under the note is only payable, it says, provided, however, principal and interest is payable only if the defendant survived Patricia Munn. But the first paragraph does not tell us a very key thing, which is when does that become due? When does the principal and interest come due? It just says if they survive her, it will be due. It doesn't say when it will be due. And so we have to keep reading. We get to the second paragraph, and that's where we have the first interest provision. And I only point this out because it goes to the consequences of what we're talking about here. So the note sets an initial interest provision in the second paragraph. That interest rate scales up depending on where we are in the life of the agreement. So the initial interest rate is one thing. It jumps on the date of maturity. And then it jumps again in the event of default. And it jumps significantly in the event of default by 150% is the default interest. It goes up to 150% of the first interest rate. So the date of default matters. The due date matters. We go to paragraph 3, and that's where we find, for the first time in the note, an explanation of when things come due. And again, this is at page 8 of the record. And it says the principal and interest comes due at one time, just one time. And that is the earlier of the closing of the sale. That's a date specific. So the sale closes on, in my example, that's April 30th. That's the date I have to sell the car. It's not April 29th. It's not May 1. It's April 30th. That's the date I have to sell it, or not. The closing date of the sale, or 10 years after the contract signed, and that would be September 6, 2029. We don't know how to calculate principal yet, so we keep reading. That's on page 9 of the note, and that says that the principal depends on whether the house is sold within 10 years. If it's sold within 10 years, it's 17% of the net proceeds. If it's sold after 10 years, it's 17% of the fair market value. And then we keep reading, and we get to the default provisions that Chief Judge Dillon, you were referencing earlier, that say that under certain circumstances, the plaintiff could accelerate the obligations due on the note, including failure to pay when due. So again, it's circular. The question is, when is it due? It does not create its own new due date.
Let me ask you a question. When this was signed, who owned the house? Just the mother?
Patricia Munn owned it with Melinda and Allen.
They all
at the time
owned
it was signed.
So the three of them all owned it together.
Yes, they owned it together.
At the time this note was signed.
Yes.
They all owned it together. And her intention was, your claim was, if to compensate the others, to make it whole or whatever she felt was a fair estate plan, that if she died, then if the house got sold, they'd get 17% plus 2% of that amount every year, whatever the interest rate for every year they lived in. So if they sold on year 9 or whatever, they'd get 17% of the sales price plus some interest rate. Is that right?
Yes, that's right. And it's important to note too that while the plaintiff is the only sibling who has brought suit, there were promissory notes signed in favor of all three of their other siblings. So there were 2 other siblings who received notes, and those notes were 2.5%.
So when the house got sold, tell me again where the money went. Did the Roses get any of it because they were part owners?
They got half of it. That's right. They took half of it, half of the net proceeds, which there was a mortgage on the homes, about $500,000. Home sold for $1 million. There was a mortgage on the homes, about $500,000. They took half, even though arguably they were entitled to 2/3. They took half. They put that with Mom in a joint account that they had.
Why were they entitled to 2/3?
Because there were 3 owners, and the
How was it deeded?
It didn't specify.
I think if a couple or if a married couple's on a deed, they're considered one unit unless it's specified.
Well, I
Go
will
ahead.
yield. I will yield to Your Honor's
Go ahead.
judgment about that. My wife would be happy to hear that. I think that there are at the time they took the money, they put half of it into an account in Patricia Munn's name and their name, so that they could pay her cost of living expenses. There's no argument. I just want to be clear about this too. There is no argument that the money was used other than to pay her living expenses and her end-of-life cost of her end-of-life care. And when, after she passed away, Melinda is the executrix under her will, Melinda took the money that was left in that account, divided it evenly, and gave it to her siblings. She did not take a share because she had already received half of the value of 6,500 Shaftesbury. Again, that's undisputed. The court found that.
So she got 250, and the other 250 got, or whatever was left of that 250 was split among the other siblings.
$40,000 each, give or take. And so, and then after he receives that $40,000 check and cashes it, here comes a letter saying, I want the rest. And not just the rest, but I want payment on top of the $40,000 based on the promissory note. And
Wait, how many other siblings are there? There's the Roses, and how many other siblings?
I believe it is 3.
So 3 other people got $40,000.
That's right. So it's plaintiff, they have a brother, Scott, and they have a sister who's also named Patricia. She's Patricia Ruth Munn. And I think that's everybody.
So there was basically the 250, then 120 that went to the other siblings. So that's 370. So he didn't quite get 17% of that, but
That's right. And look, I want to be clear too. If this note said that this was due and payable when she dies, or if it said that if these events occur and she's still alive, it will be payable at her death, I would have a much harder argument today. But the note does not establish a due date, and this was the key determination of the trial court, and it is his conclusion of law number 1. It says the note does not establish a due date in the event that she survives at the time of those quote-unquote, as defined in the agreement, date of maturity. So because of that, there's no date. You'd have to accept their proposition, you'd have to imagine that what these parties drafted was an agreement where literally as Patricia Munn is taking her last breath, Melinda and Alan would have to be stroking a check in order to avoid default under the terms of the note. And that's not what's written here, and it's not what the parties intended. What's written here is that in order for any obligation to come due, the condition precedent, this is why we call it a condition precedent, must have accrued or occurred as of the date of maturity. If it doesn't, we have no other due date. The day after closing can't be a due date. A year later can't be a due date. Under their construction, if we disregard the extrinsic evidence about Patricia Munn and her age and her health, under their construction, it could be 80 years later that the money comes due. It operates like a tolling agreement. This court and our Supreme Court has held that you can't really toll a statute of limitations like that on a payment obligation. You can shorten it, but you can't extend it. And this would be extending it.
And I'll ask them, how much do they think that they were due?
That's a great question. It's unclear from their testimony. I asked questions about that, and we tried to do some math sitting there in the courtroom.
The most would it be 17% of the $500,000 that it sold for?
That's correct. So it'd be about
$85,000. So we're here over $45,000.
And we would take the position that we would be entitled to an offset of the 40 that they already got. That's right. So their demand was for a number north of $100,000, and that was a demand.
And I'll ask them why, because the note clearly says it's the sales price minus any mortgage, and then it'd be 17% of that.
That's right. Well, there's been confusion. There's been confusion in the case, really, going back for a while. A couple of months after the home was sold, while Patricia was still alive. So Patricia dies in July of 2023. In June of 2023, the plaintiff's lawyer sends a letter to the defendants demanding full payment on the note. Well, she's still alive. And the defendants write back and say, well, it's void. She was still alive when the property was sold. And they appear to have accepted that at the time, and that's the question about testimony, and my friend brought this up, and he called it sort of a misleading finding. It is true that In the middle of his testimony, the plaintiff acknowledged that the note did not come due at the date of sale. He tried to say the note came due on the date she died. That's the position that they're taking, and that is simply divorce. There's nothing in the note that says that. The note says that it will be payable if she dies, not when she dies. There is no provision for when. As the trial court found then, and I think this is a good place to leave this part of the argument, unless the court has questions, the trial court found at paragraph 26 of its order to impose a due date under the circumstances here would be to read a provision into the contract that is not there. You would have to say, we are going to treat if as though it means when. And I don't know, that's not a reasonable construction, and that's why we don't have an ambiguity here. If is a present condition, when is a future condition. With respect to the meeting of the minds, so throughout the trial court's order, he references whether there was a meeting of the minds on a specific point, which is the question of if Patricia were to die after the sale, whether there would be any obligation under the note. And the trial court starts, and this is important because he didn't just go rogue and start looking at every little thing. He started in paragraph 32 of his findings with a very specific explanation of why the plain language of the note and the four corners of the note did not answer that question in his view. He said, my reading is there's no specific provision for it, and I don't see any reasonable inference that I could draw with respect to it. He could have stopped there. The trial court could have stopped there. But he went on to say, was there any extrinsic evidence, anything, that would support the plaintiff's interpretation? And he found none. Not one finding in support of the plaintiff's interpretation or reading of this note. And so ultimately concluded they simply never had an agreement under these circumstances. Everyone presumed that when Patricia passed away, she would still own her 50% of the house, and Melinda and Alan would inherit it. Because that presumption turned out to be false, they didn't have a provision in their agreement that the plaintiff was entitled to enforce in this case with respect to any amount owed.
Well, I think the intent was if there's three other children that they would get half and the other three would split the other half, 17, 17, 17. That's where I guess those numbers come from. Is that right or wrong?
No. So
she had 17, the other one's got less than that. That's right.
So the estate plan, the extrinsic evidence in the trial court's findings on that point were that what Patricia Munn intended was for Melinda and Alan to receive roughly 73% of the value of 6,500 Shaftesbury. And if that seems like a very specific number, it is.
This is 17, 3, and 3. That's right.
And that number had been discussed, again, for decades. That there are letters in the record that were admitted. There's a holographic will in Patricia's hand that talks about it. It's throughout the estate plan. The trial court makes several findings about that. And so the idea was they would split the remaining 26, 27%. And that's how they structured the deal.
And why didn't the plaintiff get a lion's share of that 120 that was left over? Why did they split that in thirds rather than him getting a large portion of the other two sons?
I don't know why they.
And they're not parties. They have the money, and they're not parties to this lawsuit.
That's right. They weren't asked. There's no testimony to that below. I don't know the answer to that question, and it's not in the record before the court. But what is in the record are the trial court's numerous findings about the purpose and the intent behind this instrument. And so that brings me to the final point, which is if we do get to ambiguity, really their only argument is that paragraph 33 of the trial court's order contains a mistake. And it's true, it does. It says that the plaintiff signed a 2018 addendum to Patricia's will that sort of outlined some of the things we've been talking about, her intentions with respect to the property. He didn't sign that, that's a fact. But the rest of that paragraph about what the addendum said and what Patricia had in mind, Patricia being the person whose lawyer drafted this promissory note, plaintiff paid for the note to be drafted, is all correct. And if you take that finding away, if you take away the finding that the plaintiff signed the addendum what you're left with is still a litany of findings that support the conclusion that the parties did not intend for the note to operate the way they think, and no findings that support the contrary conclusion. So yesterday, the plaintiff filed a notice of supplemental authority. I just want to address that very quickly because we did not get a chance to address it in briefing. It's a case that they pulled from this court's March 4 opinions. It's Wheeler versus Wheeler. And I think, and I'll be interested to hear my friend explain the pertinence of that case, but I think that they would say that the pertinence of that case is that it shows that if you've got a mistaken finding, that you've got to send it back down. You have to vacate and remand in that circumstance. That's not the law. Under Rule 61, orders and judgments don't get reversed just because there's a mistake in them. The mistake has to be prejudicial. It has to have affected the outcome. Our courts of appeals are not, they don't exist to sort of scour trial court orders and find little errors and send things back down. And so, but Wheeler versus Wheeler is also distinguishable on its face. It's about Section 50-20 of the general statutes, which is equitable distribution and the distributional factors. And the trial court used some factors it should not have used under the catch-all provision. And under that section, as I'm sure this court's well aware, the trial courts can assign whatever weight they want to whichever factor. And so if you have that multi-factor decision where you're ticking off a list and you're saying this factor goes this way, this factor goes that way, it's very difficult for this court to do its job and to say, where was the weight assigned? So in those circumstances, our precedent says send it back down. That's nothing like what we have here. Here, all of the findings were in favor of our position. None of them were in favor of their position. And we're not applying a multi-factor statutory test. So for all these reasons, we should win on the plain language, we should win on the meaning of the minds issue, and we should win on the ambiguity theory, and I'd ask this court to affirm.
Thank you. We'll hear from Bodel. My first question is, what's the amount due under the note? What do y'all argue is the amount due under the note?
17% of the sale proceeds, the net sale proceeds of,
Which is $500,000, is that what it was?
no, it's like 140 grand.
That's 17%.
That's the 17%.
17% of the net proceeds from the, and just to be clear, because he stood up here and argued mostly facts, which I'll get to in a minute. The factual record is that these folks for years acknowledged my client's continuing contribution to them in order to keep them in that property. And Mr. Cottle just stood up here and said, well, you know, there are no findings whatsoever that support Harold's position.
What did the evidence show was the net proceeds from the sale? Because they just said it was $1 million minus a $500,000 mortgage. Was it?
Yeah, it was like $563,000 or
Well,
something.
17% of that is only like $85,000. So what do you come with?
I mean, if there's a math error, it was always, there was an interest component and other stuff to that gave us the 140. But
Okay, that's fine.
17% of whatever that number is, okay?
With an offset of 40 for what he'd already been paid?
The 40 was paid through the estate. The 40 was paid through the property of Patricia Munn that was part of the estate. They're very good at this. They're very good at confusing the estate concepts with the contract between his clients and my client for under this promissory note, which he just stood up here and he said there's no findings, and Judge Smith made no findings whatsoever that, in support of their position, finding a fact 21, finding a fact 22, Plaintiff's Exhibit 1, which is at Record Supplement 3, came into evidence unrebutted by them. Plaintiff's Exhibit 1 shows by the greater weight of the evidence that the plaintiff made periodic payments to or for the benefit of his mother, Patricia Munn, at least from 2002 until her death, period. So when you talk about consideration and what they were getting there.
Aren't there other findings that he hadn't made any payments to her within the last year, excluding maybe a birthday gift or Christmas gift or something like that?
There is a finding that the payments made to the Roses immediately before, that is finding of fact number 22, that the payments made to the Roses, his clients, immediately before and after the signing of the note were gifts to them. But the court also makes the finding that I just read to you, that he continued to provide support to or for her benefit until the time of her death. And when you look at plaintiff's exhibit number 1, which came into evidence unrebutted as substantive evidence, he continued to pay Patricia Munn $1,000, $2,000, $1,000, $2,000, etc., until the time of her death. Sometimes they have descriptions on them: sink repair, mom ramp, paid off refrigerator. So these folks admitted under oath that they had no other place to go if the property got sold. And the court's, so here's what the court found. And this goes directly to this argument about finding of fact number 33. So first off, the court found that we had a reasonable argument about interpretation. Unlike Mr. Caudle saying.
I'm looking at finding of fact number 23 that says plaintiff's only payments shortly before and after the contract for which he made entries were birthday, Christmas, and Mother's Day payments to his mother. No payments were made to defendants for more than a year, and these show they were intended as a Christmas gift and to pay the lawyer who drafted the document.
Correct. Patricia Munn was not a defendant. The defendants are his clients. So.
But it said only payments were birthday, Christmas, and Mother's Day payments to his mother.
Shortly before and after the contract. But the contract was signed in 2019. He made payments through 2022, as shown on plaintiff's exhibit number 1. And those payments are reflected in the court's finding of fact 22 earlier, which said the great array of the evidence that plaintiff made periodic payments to her for the benefit of his mother, Patricia Munn, at least from 2002 until her death. So he did, yes, immediately before and after the contract was signed, there were some birthday and Christmas presents given to Patricia, but he continued to make payments to allow them to stay in that property until the time of her death, or until the time of the sale, which was shortly before her death. And so so anyway, Judge Smith, who's a venerable, seasoned Superior Court judge, he felt like there was an ambiguity. And because he felt like there was an ambiguity, he examined what he deemed the parole evidence in the case. And if you look at...
Well, I thought your client's position was that the language was plain and unambiguous.
Yes, both parties' positions are the language is plain and unambiguous. But in terms of the order you're reviewing, Judge Smith apparently didn't buy either party's contention that the language was plain and unambiguous, because he engaged in an examination of what he deemed the parole evidence to determine the meaning and intention of the contract.
Is it possible that that was in the alternative?
Well, he didn't say it's in the alternative. He said... Is
it possible that it was in the alternative?
Yes, it's possible. But the order on its face does not say that. In fact, what the order says...
Do we even need to get there if we decide that the language is plain and unambiguous?
Yes, you need to get there for this reason and this reason alone. Well, actually, no, you don't need to get there if you determine as a matter of law. But my point is that, to follow up on the questions from the panel, you've got two competing interpretations of this contract. The trial court judge didn't say, you guys are at the lunch. The trial court conducted a 2-day trial and made detailed findings, including a finding number 33, which they say, pay no attention to that, Your Honors, which is the linchpin of the court's. So the evidence at the court, which was unrebutted, was Al Munn found out that his sister and brother-in-law had put their names on the title in 2019. He went to them and he said, I'm not making payments anymore. The payments stopped. And he testified to that, and Melinda said that that conversation was, quote, possible, but had no recollection of it. She never rebutted it. So Judge Smith, in finding of fact 33, said, well, the reason why they entered into this promissory note was because it was part of Mom's estate planning. And in support of that, he made a detailed finding that my guy signed this addendum when not only did he not sign it, but he didn't know about it. So when he talks about Wheeler, when he talks about, he doesn't talk about the other cases that we cite at pages 36 and 37 are brief. Allen, yes, if there's incompetent evidence and then there's other evidence in support of that, generally this court says, okay, there's other evidence in support of that. But the court has also said that in the absence of words or contact indicating otherwise with respect to the effect on the trial court judge, you are going to send it back. Now, we don't want it sent back. We want it resolved. And to follow up on Judge Collins' question, if you resolve it as a matter of law, you resolve it as a matter of law. But the trial court clearly considered the, quote, totality of the evidence and finding we hadn't met our evidentiary burden. And if you take 33 out of this, there's no way you can determine, well, he would have made the same conclusion without that finding. You can't do that. And so the cases we cite indicate that in those, and I mean, look, I practiced 35 years. This isn't an incompetent finding. This isn't that there was evidence that came into court, came in before the trial court violation of the hearsay rule or wasn't authenticated. This is made up.
Let me make sure I understand your interpretation of the note. Let's assume the net proceeds was $500,000, but let's say it wasn't sold till a year after Mom dies. I mean, I guess in the estate had, when Mom died, the house was all owned by the Roses. Is that right?
Yes, as far as I understand.
So that if it got sold a year later, your client would have gotten 17% of that. Is that
Yes, sir.
Okay. But if she died a year before and the property got sold and your client got $40,000, your interpretation is he still gets, on top of that $40,000, because that went through the estate, still gets 17% of that $500,000 on top of that $40,000.
Correct, because the $40,000 is not part of the equity of the house, A, and B, because it was recognition of the support he had paid over the years. So there's no windfall to Al Munn at all.
Yeah, because he would get another $40,000, because that $40,000 would not have been in the estate if it was sold after she had died. There's a windfall since it was sold before the house, because you just told me if it was sold a year afterwards, he would only get 17% of that $500,000. But now you're telling me if it was sold a year before, not only does he get the $40,000 from the net proceeds from that house that went into the estate, he would also get 17% of $500,000.
Judge, I'll be honest with you. I don't think the $40,000 is tied to the net proceeds of the house. There was a net estate that went through the estate process that each sibling got $40,000. So, but my point is that the money from the proceeds from the sale of the house is different than what the net estate was. So he wasn't getting a windfall. He was just enforcing.
Where did that money go?
Huh?
Where did that net proceeds go that went to Mother? I mean, she got some of that. She got half that net proceeds. Where did that go?
If I remember,
none of that ended up in her estate.
I think the money did actually wind up in joint accounts for right of survivorship, and the folks that were signatories on the accounts were Pat Munn and his folks. And so when she died, that money also went to his folks through.
So was that money used to provide for her end-of-life expenses, including assisted care?
I don't know. I'd have to assume so. But again, there was only 2 months of assisted living expenses. I mean, the house closed in May. She died in July. So, but yeah, that money could have been, and the court may have made a finding to that effect. And assuming it's not a mixed finding, which we argue earlier in the standard review section, Higgs, at page 9, you're not bound by mixed findings of fact of law, and there are a bunch of them in this order, then yes, some of that money would have been used for her end-of-life period.
You can spend a minute to wrap up if you want to.
I feel wrapped up. I think you guys get the case. So I appreciate the court's time and attention to this matter. Thank you.
We will take it under advisement, and we're ready to adjourn. Thank you for your great arguments. All done?